The Remedies question from July of 2003 is one of the most hated and feared questions in recent memory. It is testing an obscure, tiny little bit of law, and it is a bit of law that hardly anybody who sat for this exam really knew very well. Have a look at the call of the question. What remedies, based on trust theories, might Polly and Acme seek against Donald as to the house sale proceeds? What defenses might Donald reasonably assert against Polly and Acme? And what is the likely result as to each remedy? Discuss. Trust theories? As I first looked at this question, the first theory that came to mind was a constructive trust, or perhaps breaches of duty by a fiduciary. And as it turns out, this really is factually a tremendously complicated question. And the obscure little bit of law that's being tested is a purchase money resulting trust. A pretty obscure bit of law from the law of real property and contracts and remedies. Now, putting aside our harsh feelings about being called on to discuss trust theories, this call of the question does lend itself to fairly easy organization. We know we're going to have two different lawsuits, Polly versus Donald and Acme versus Donald. And we know that in civil litigation, the plaintiff is going to have a theory of liability. And we know that the theory of liability that each of these plaintiffs is going to rely on is some kind of trust theory. And we also know that the remedy being sought is damages based on some house sale proceeds. And we also anticipate that the defendant, Donald, is going to have defenses to the theory of liability presented by each of the two plaintiffs, and then we're called on to determine the result. So, again, putting aside our harsh feelings, it isn't hard to organize an answer to this question before we even read the fact pattern. Now, have a look at the top of the question, and it doesn't take long to figure out that this is a fairly complicated question. And the only innocent party in this question is the plaintiff, Acme. Have a look at paragraph 1. Here we learn about a real estate transaction back in 1993. Polly and Donald orally agreed to purchase jointly this house on Willow Avenue. Okay, well, stop right there. If we've got an oral agreement, we can anticipate that one of Donald's defenses is likely to be the Statute of Frauds. We see here in paragraph 1 that both of these parties contribute $20,000 to the down payment. Polly is paying her $20,000 share in cash. Donald is paying his $20,000 share in money he embezzled from Acme. So at this point, we have met all three parties, Polly, Donald, and Acme. And in paragraph 2, we find out that Polly is not a lot more sympathetic than Donald. We already know Donald's an embezzler. And in paragraph 2, we find out that Polly is trying to avoid judgment creditors. And obviously, these judgment creditors would much rather take this $20,000 away from her than see her invest it in this property. And in the remainder of paragraph 2, we learn about more of the details of the oral agreement between Polly and Donald. And as it turns out, in paragraph 3, Donald lives up to his end of the agreement. In 1997, our plaintiff Acme discovers Donald's embezzlement and fires him. The next year, Donald vacates the house and rents it to tenants, again, using the rental payments to cover the loan payments and the maintenance costs. So again, it appears Donald is living up to his end of the bargain. But in 2003, Donald sells the house, pays off the loan, and pockets $100,000 net to himself. And Donald offers to repay Polly her down payment, and Polly wants half of the net proceeds. Then, in the next to last paragraph, Donald finds himself pursued by Acme also, who wants the $100,000 from the property, or at least the $20,000 Donald embezzled. And we learn that Donald has no assets apart from the house sale proceeds. The last paragraph is the call of the question. So, we see that analyzing the facts is going to be central to any sort of success on this question. But the basic organization we were able to figure out before we even read the complicated facts. Now flip the page and have a look at the outline of issues that I've offered, and you'll see that all I've done is flesh out the initial outline that I was able to think of just by looking at the call of the question. We see that Polly is going to be suing Donald for breach of contract. That's one detail that I add, her theory of liability. And she's also suing him based upon a purchase money resulting trust. Now, let me just pause right here for just a moment. Suppose you understood that there was something special about this contract that would entitle Polly to relief, but you didn't remember the name, purchase money resulting trust. I would suggest that it would be appropriate to have a little section in your answer internally where you would discuss it based on the oral agreement and fairness. Work in all of the facts and then move on to consider what I think most of us would be able to think of, the constructive trust theory. Then, notice, this defendant is not without defenses. He's got a statute of frauds defense and an unclean hands defense. And it is another example of a situation where one could readily come to a conclusion on either side. As it turns out, I'm going to conclude in favor of Polly, perhaps breaking my self-diagnosis of having a defense bias. But notice, with regard to Donald's defenses, he can argue the statute of frauds and unclean hands with some substance. Then in Part 2 we consider Acme's lawsuit against Donald. The theory of liability underlying its identical theory of Polly's, the purchase money resulting trust, is Donald's earlier embezzlement or conversion of the money that he used for his down payment. So, again, I talk about the purchase money resulting trust and the constructive trust. But here, Donald has different defenses for Acme's claim that are, perhaps, meritorious. Those are the statute of limitations, for one thing, and also laches. So in both of these lawsuits, there is plenty of room for reasonable people to differ and to arrive at opposite conclusions. But I think you'll agree that really carefully analyzing the facts is central to success regardless of which conclusion you end up arriving at. Because the depth and breadth of your analysis is what will best support whichever conclusion you reach. And I think you'll all agree with me that Acme is the only character in this question that is at all sympathetic, because Polly and Donald are both basically dishonest. So now let's have a look at my model answer, and let's see how I lead off with the facts, and I indicate the underlying nature of the lawsuit. Then I get into Polly's breach of contract claim, and I spell out the details of their oral agreement, and then I go on to consider their performance of that agreement. And it seems to me that as a result of the facts that I explain, Polly really can make a prima facie case for breach of contract. Then I go on to consider the purchase money resulting trust idea. And here, as you read it, I'm sure you're all familiar, at least vaguely, with this purchase money resulting trust idea. And if you're not, this is a good place to become familiar with it. But notice that the actual content is not that complicated, and there isn't that much of it. And so I essentially go through the details and I reach a conclusion, which is that the plaintiff could well prevail on this purchase money resulting trust theory. Then I go on to consider a constructive trust. And notice here how I lead off with a compact but fairly complete definition of what a constructive trust is. And I explain how the court will be acting as the settlor, ordering Donald to be the trustee, with his only duty being to turn over to Polly her share of the profits from the house sale. Now, basically, I'm suggesting that here Polly also has a pretty good claim. Then I turn to Donald's defenses, both of which I think have some merit. I turn to his Statute of Frauds defense. And here, it seems to me that we have to choose between allowing a bad guy to profit from using the Statute of Frauds and a bad woman to profit if she overcomes the Statute of Frauds. I pick the lesser of two evils as I perceive them, and I come down on the side of Polly. And similarly, with regard to unclean hands, I think that vis-a-vis the interactions between Don and Polly, Donald has not been honest, and Polly has. So I conclude that Polly ought to win her case and should get the $50,000 that she's seeking. Now I turn to the second lawsuit, Acme versus Donald. And this is actually quite a different case. And notice here again how I lead with the facts to explain the relationship that these parties have, and then I go into analyzing Acme's embezzlement and conversion theory. And here, notice I do lead off with a concise but reasonably complete definition. And then I explain how Acme can establish a valid embezzlement theory and also a purchase money resulting trust theory. And so I conclude in favor of this plaintiff, and I also indicate that of all of the parties in this question, Acme's the only one that is blameless. But in Acme's action, Donald has potentially successful defenses, notably the statute of limitations. And it is quite possible that a 5-year plus time lapse is enough to bar the action altogether. And then I go on to consider laches briefly. In the end, I conclude that Acme probably loses as a result of the statute of limitations. But if the case proceeds beyond that defense, the statute of limitations defense, I say Acme will win and will recover $50,000 from Don. And that wraps up a consideration of a question that I think you'll agree is actually quite easy if you know the law. And if it isn't, if you don't, it's quite a hard question. Either way, I hope you found it instructive.